All right, is there a Michelle Harpo here? Michelle Harpel. All right,
Raise your hand.
can you unmute for me, please?
ma'am.
Hi, the motion on your case was withdrawn, so you're no longer on probation. I hope that you've learned some things, and I hope we won't see you back again. You understand?
Yes, ma'am.
If you have a drug or alcohol problem, or there's something going on in your life, there are a lot of places that are open, a lot of places that you can go to for free. Do you understand?
Yes, ma'am.
All right, good luck to you. Kevin, do you need to speak with her?
No, Judge, that's why I was asking.
All right, you're excused.
Thank you.
You're welcome. All right, everyone, please make sure you're on mute. These are the rules of the 187 District Court. You're in the 187 District Court. Happy Friday. Let's keep it as a Friday. Let's not turn it into a Monday. If you are at your work, if you are at your house, if you are in your vehicle, you need to find a stationary place. You need to find a quiet place. You are not allowed to drive and Zoom. You are not allowed to do laundry. You are not allowed to lay in bed or fix breakfast or whatever. If you can't do it, if you were physically in the courtroom, you can't do it on the Zoom screen. If you behave inappropriately on this Zoom screen, your Zoom privileges will be revoked. Doesn't matter if you're out of county, out of country, out of state, you will be required to appear in the 187 District Court. And let me tell you what will happen when you appear in the 187 District Court. In order to get here, you're going to have to take a via. You're going to have to take an Uber or a Lyft. If you take a via, that costs money. If you decide to drive downtown, what's going to end up happening is you're going to find a bunch of one-ways. As I discovered, there's so much construction going on downtown. A normal 5-minute drive takes you 20. And then if you're able to find parking space, you're going to find that parking downtown has become very expensive. So let's keep it a Friday. Let's not try to turn it into a Monday. To all the inmates, you're not allowed to use the chat box. If you use the chat box, you will be sent back. To everyone on this Zoom screen, this is not the Bachelor. This is not the Bachelorette. If you want to pick up a date, you need to do it on your own time. You cannot do it on this Zoom screen. Inmates, you are not allowed to use the internet at all. You're not allowed to use Facebook. If any of those things happen, you will be sent back to your cell and we will probably be able to see you in 30 or 60 days. I'm going to open breakout rooms. When I open breakout rooms, it will invite everyone to a breakout room. Do not, I repeat, do not go to a breakout room unless I specifically call you by name and assign you to a breakout room. To all defendants, I'm going to call the name of your attorneys this morning. Your name will not be called. If you do not hear your attorney's name, one or two things have happened. Either your attorney is Zooming in another courtroom or your attorney was required to appear somewhere in person. Your attorney will come on this Zoom. Just be patient. Attorneys, this is the order in which you'll appear. If you see your name low on the list, you're more than welcome to Zoom to another courtroom. However, if you Zoom to another courtroom, your name is called, you will be placed at the end of the list. Attorneys, do not text, do not chat, do not email, do not call Ms. Ferguson. She's the court coordinator. Do not call her requesting that you be excused. I'm the only person who can do that. If you have a plea bargain agreement with the state, no matter how small you think that plea bargain is, you need to place it in the chat box to Ms. Ferguson. And everyone, please make use of the chat boxes. It makes the Zoom run so much smoother when people are not talking over each other. Attorneys, when you come from the breakout room, if you want my attention, just raise the hand sign that's on your Zoom and I will see you. Attorneys, this is the order in which you'll appear. David Cuellar, Jonathan Watkins, Alma Benavides, Orlando Castagnon, Sean Sheffield, Robert Brauback, Patrick Valentine, James Milan, Laura Lefton, Joel Perez, Warren Wolf, and Anita Garza. Is there any attorney whose name I did not call? All right, attorneys. Prosecutors have the ability to move throughout the breakout rooms. When you're assigned to a breakout room, Think of that as going to the doctor's office. When they call you back to the small room, you're not seeing the doctor. Mr. Flores, I don't know why you have change out. There's nothing happening here that requires you to have your dollar bills out, but you need to put that away. All right, attorneys, think of the breakout rooms as going to the doctor's office. When you go to those breakout rooms, doctor's not seeing you right away. They're just checking your weight and your blood pressure. So be patient. Everybody put some patience in your pocket. If you do, take it out when needed, and this will run smoothly. Attorneys, when I call your name, I need to know the name of your client. I need to know whether or not it's criminal trial division or family violence. If you have the ability to change that name in your chat bot, in your as your assigned name, it'll make things run so much quicker. All right, David Cuellar, who do you have?
Yes, Your Honor. I have Mark Anthony Hurtado, cause number 2021-6028.
Don't need the cause number. Just need to know your attorney's, your client's name and whether or not it's criminal trial division or family violence. So what's his name?
His name is Mark Hurtado. Hurtado is the last name.
How do you spell the last name, please?
Hurtado.
Criminal trial division or family violence?
It's criminal trial division, Your Honor, and he has been accepted to the PTD program.
All right, just give me one moment. I'm going to send you to breakout room number 1 with Miss Ferguson. She's going to give you a date. When you get that date, come back to the main room.
Yes, sir. Thank you.
And I will send you to breakout room number 1.
Yes, sir.
And Miss Ferguson, if you could go to number 1, please. Jonathan Watkins.
Good morning. Happy Friday, Judge.
Happy Friday.
Obed Urdiales, and it is CTD. I've been conferring with Mr. Sanders.
Okay. I'll send you to breakout room number 2.
Thank you, Your Honor.
You're welcome. And tell everyone, your attorneys are probably going to want to speak to prosecutors first. So when they want you to come to a breakout room, they will request it and you will be sent there. Alma Benavides.
Good morning, Your Honor. I'm here for Edward Ramirez. It's on the Criminal Trial Division. He's in court this morning in person for an in-person plea. I've been conferring with Marcus, and I just want to firm up a couple of things on the plea bargain before we get the paperwork started.
All right, I'll send you to breakout room number 3.
Thank you, Your Honor.
You're welcome. Orlando Castagno.
Yes, Judge, I'm here on a couple of people, one of which is Manjarres brothers. I'm joined here with James Juan, who is representing the other brother, Andres. I represent Jose Manjarres. And we had an issue in regards to a Padilla letter, and I guess they're applying for citizenship or making sure they're citizens. And I don't know if James wants to speak to that.
Yes, Judge. So as of the last setting, we were looking at like an 8 to 12 week window as to when the State Department was going to act on the passport application that the Manjarres had sent in. At that last setting, they had received a letter from the State Department saying that there were some more documents that they had requested. They submitted them the following week. So we're probably in a 60 to 90 day window before we know whether the passport.
Just 1 second. I'm going to get back to you with the brother Manjarres. Because we need the immigration attorney in here.
Oh, okay.
Mr. Castagno, who's your other client?
And then I have Trey Duncan, and I'm not sure if he's in court or not.
He's not in court.
I was not able to reach him.
All right, and it's criminal trial division?
It is.
All right, I'm going to send you to number 4. And the immigration attorney, that was Cos Davila, correct?
That's correct, Judge.
All right, so let me send her an invitation to come. Just give me a moment. right, my system is slow, so it's probably going to take about 5 to 10 minutes for that email to go forward. Sean Sheffield.
Good morning, Your Honor.
Good morning. Who do you
I
have?
have Maribel Caceres. It's a criminal trial division, Your Honor.
How do you spell the first name?
Maribel.
Thank you. I'll send you to breakout room number 5.
Thank you, Judge.
You're welcome. All right, David Cuellar.
Yes, Your Honor.
Mark Anthony Hurtado.
Yes, ma'am.
What date did you have?
We were given the date of October 20th.
All right, and where is your client?
I'm so sorry. I said I didn't.
You're
want
on
you
mute. You need to mute yourself, Mr. Milian. All right. On Mark Hurtado, where's your client?
I'm trying to find him. I did communicate with him this morning and gave him the address. I'm not sure who he is.
All right, as soon as your client comes in, I'll give him his court date and he'll be excused. Just one moment. Robert Brauback.
And Judge, my client is Anthony George Cardenas. He's present. We have a plea worked out with Morris Hunter. We just need the paper.
All right, what is the last name?
Cardenas.
All right. Just one moment. I'll send you to number 6.
Thank you.
You're welcome. Patrick Valentine.
Good morning, Judge. I'm here on Noah Cruz. That is a family violence case. We have a plea worked out. I need to talk to David Martin about a couple details, but we should be able to get that done today.
All right, thank you. I would give you an A+, but you didn't put whether or not it was family violence in your name.
Oh, okay. I should have.
All right, I'll send you to number 7. You were so close. And Patrick, before you leave today, Norman, I need to speak to you about that writ issue. I don't know if you've been given deadlines by the 4th court.
Oh, yes, ma'am. We can talk about
All right, thank you. I'll send you to number 7. All right, and James Milan, you're just here on the Brothers Monjarez, correct?
Correct, Your Honor. And I believe Ms. Coles Davila is signing on.
Yes, I sent her the email. Thank you. All right, Laura Lefton.
Good morning, Your Honor. How are you today?
Oh, I'm
Hi.
doing great. It's Friday. Thanks for
Exactly.
changing your name.
No
I'll see you
problem.
in number 8.
Awesome. Thank you, ma'am.
You're welcome. You made it so easy. I told everyone they make it so easy when they put the names in because then I don't have to type.
I'm learning slowly.
But the downsides to that is I'm not brushing up on my typing skills.
I'm sure you have plenty of other reasons to type. So thank you, ma'am.
All right, you're welcome. All right, Joel Perez. You're on mute.
Yes, Your Honor, I was just trying to unmute myself. Good morning.
Okay.
I've got Juan Reyes, Your Honor, he's on the Zoom. Charles Bunk is a special prosecutor on this case. I've already informed him that Mr. Reyes has declined the plea offer. And
All right,
so
but I'll need Mr. Bunk to zoom in.
I texted him, Your Honor. I don't know if he's in another court or whatever the case might be, but that's our announcement.
Okay. All right. As soon as he zooms in, we'll get a trial date.
Okay, Your Honor, thank you very much. I'll try and reach out to him.
All right. Thank you. Warren Wolf.
And I'm all unmuted. I'm returning from the other day on John Perez. Sean Keys and I represent him in both civil trial and family violence. I had been dealing with Mr. Morris, and Mr. Keys was dealing with Mr. Martin.
All right, just give us a moment. As soon as Sean zooms in, we will put you in a breakout room. So don't leave yet, but your assigned room number will be number 9.
I don't know if Sean got the link. I put a blast out and
Oh, no, he would have received the link.
I didn't receive it this morning.
Oh,
I got it from another attorney.
well, that's odd.
Well, that's
Just
what
a
happened.
moment. I don't see your client on the docket. What's the case number?
Judge, I sent you a chat.
All right, what's the case number, Warren? And he proceeds to go to number 9. Everyone, I will be right back.
Hi, good morning.
Good morning. Ms. Davila, just give us one moment, okay?
Sorry. Yes, thank you.
No problem. Melissa Christian, thank you for changing your name. I'm going to send you to breakout room number 10.
Thank you.
And what pen are you wearing today?
It's an eagle. I don't know if the court can.
I like it. I see it. Thank you. I'm going to send you to number 10.
Thank you, Judge.
Matthew Allen. Matthew Allen.
Yes, Judge. I'm here on, I have 2 cases. One is Paul Donaldson.
Objection.
And I did confer with Tom this morning. It's a bond reduction, but my witness is not available. I was going to see if we could recall it for next Thursday or Friday if the court was available.
All right. What I'll do is I'll send
agreed,
you.
Judge.
You're agreed to that date.
Mhm.
Ms. Ferguson, on Donaldson, do we have one of those dates available? Which date, Mr. Allen?
Thursday or Friday?
I can do Thursday.
Okay, that would work if that's good with the court.
Yes, so on Mr. Donaldson, we'll be back on September 23rd.
Okay. And my other case is Daryl Simmons. We're here on a discovery compliance. I was conferring with Marcus. He emailed me saying that the items no longer exist. So I believe we have all of the discovery that is available.
Okay, just give me one moment. And do you need to speak with Mr. Donaldson? Because he's in custody?
No, Your Honor.
All right, Norma, can you counsel Mr. Donaldson then?
Yes, ma'am.
And then your other case is which one, Mr. Allen?
Daryl Simmons.
We've lost Mr. Allen.
It was Daryl Simmons, Judge.
Okay. All right, as soon as he zooms back in, we'll take care of that. Ah, there you are. All right, and what is happening with Mr. Simmons?
I believe we were set on discovery compliance. Marcus looked into the items and they either don't exist or no longer exist. So I believe we have all of our discovery now.
Okay. Has an offer been tendered?
No, Judge, I don't believe so.
All right, so I'll send you to a breakout room to confer with the state on an offer.
Okay.
And let me just remove Mr. Donaldson from your name. And I'll send you to breakout room number
No, Judge.
11. All right, so if you'll go to 11, please.
Yes, Judge, thank you.
All right, Teresa Coles Davila.
Yes, Judge. Hi, good morning. I'm sorry. I didn't know I was needed this morning.
Oh, no problem. The defense counsel is telling me there's still some passport issues or something with the brothers Manjares.
Yes, Andre Manjares had submitted an application to the Department of State for his passport, and the Department of State wrote back to him and requested additional information. It's my understanding that he did supply the requested additional information. He sent me a copy of it, so I don't have any reason to believe that he didn't. So that's still pending with the Department of State. So they haven't made a decision on it yet.
All right, and how long do you think that will take?
It's really hard to guesstimate, but 60 to 90 days, I think is, I know, it's, I don't even know if that's the turnaround time, but I'm guessing. When there's a request for evidence, it kind of puts it outside of the normal processing times. So it's hard to gauge when their decision will come out, but that should be around the time frame.
All right, so what we'll do is, Ms. Ferguson, can I have a 45-day reset? And we'll see where we are at the 45-day mark.
Yes, ma'am. Okay.
1 second. And Milan, where is Manjares?
You should be on.
I'm right here, Your Honor.
All right, and are you Andre or are you Jose?
I'm Andre.
All right, where's Jose Manjares? Oh, you're muted.
There you go.
All right, thank you. Andre, why are you not at work?
I
Usually seeing you in your work gear.
yes, I was doing my court.
Okay. All right. Usually you're calling from your employment. So I didn't recognize you in this gear.
No, of course, it's my new jacket. But yeah, as soon as I hang up, I gotta go back to work.
Okay. All right, Norma, what's the date?
Judge, I can either do,
No, just give them one date.
I can do the 10th, November 10th.
All right, we're going to come back on November 10th. And we will see where we are. Both of you are excused.
Thank you, Your Honor. Have a great day.
Thank you, you too. You all have a good one.
That's all I have, Your Honor. May I be excused?
All right. Yes, you're excused. Thank you,
Thank
Ms.
you, Judge.
Davila. Thank you.
Thank
Have a good
you.
Friday.
Yeah, you too. Thank you very much.
All right, everyone, just give me a moment, please. Mr. Martinez, if you were here on Michelle Hopper,
Yes,
Your
that case has been terminated, so she's no longer on probation.
That's what I was going to double check on, Judge, but I had one other person, Patrick Samaniego, the guy that we keep coming back on, who has a case in another county.
All right, just give me a moment.
I was working on Lugo all week, so I'd tell Ray what's going on.
Criminal trial division or family violence?
It's criminal trial, Judge.
All right, I'll send you to breakout room number 12.
What is your name?
Thank you.
All right, and Miss Perez on Haggerling, I see you. Just give me one moment. Norma, I'm sending you a chat.
Okay.
All right, Mr. Wolf, where are you? Warren Wolf.
Right here, Judge.
Hi, I think there was a miscommunication issue. Norma, can I have a date for Mr. Perez, please?
I can do Monday, Judge.
All right, so we're gonna bring your client in on Monday.
All right, have a good weekend.
All right, thank you, you too. And Norma, one of his cause numbers is 2021 CR 1784.
Thank you.
You're welcome. All right, Alma Benavides.
Yes, Your Honor. I'm just waiting on paperwork
All right,
from,
thank you.
thank you, Judge.
All right, Ms. Ferguson, I'm going to send you to breakout room number 1, Charles Bonk to breakout room number 1 to confer over jury trial date, and hold Perez to breakout room number 1, please. All right, we will see. Brenda, we're going to go on the record. And we'll see if this is working today. Oh my goodness, Brenda, it is working. All right, the court is calling 2017 CR 2184, State of Texas versus Juan Enrique Reyes. Can I have parties announced for the record for the state? Oh, you're on mute, Charles.
Charles Bunk for the state of Texas.
And Joel Perez for the defendant, Your Honor.
And are you Juan Enrique Reyes?
Yes, Your Honor.
We're proceeding by video because of the pandemic. Any objections from the state?
No.
Any objections from the defense?
No, Your Honor.
Mr. Reyes, do you have any objections with this proceeding by video?
No, Your Honor.
All right, Mr. Perez, have you received all the discovery in this case?
I have, Your Honor.
And just let me check my file to see if an acknowledgement of discovery has been tendered. All right, the court does not have an acknowledgement of discovery in its file. State, I'll need an acknowledgement of discovery completed by October 29th. Will you be able to do that?
Absolutely.
State, did you tender an offer to defense?
Yes, I did.
Mr. Perez, did you receive the offer?
Yes, Your Honor.
Mr. Reyes, are you rejecting the state's offer?
Yes, Your Honor, I am.
Are you requesting a jury trial?
Yes, we are, Your Honor.
Yes.
All right, your jury trial date will be January 12th, 2022 at 9 a.m. You will need to be present in the 187 District Court on January 12th, 2022 at 9 a.m. dressed for trial. The court is located at 300 De La Rosa. It's the 187 District Court. If for any reasons jury is still suspended, your attorney will let you know, in which case you will be appearing by Zoom. Do you understand?
Yes, Your Honor.
When is your jury trial date?
January 12th, 2022.
What time?
I'm usually there by 6 or 7 o'clock, so.
Okay, but it's at 9 a.m., but it's okay if you're here by 7. No one's
Right.
here until 8.
I understand.
All right, which courtroom?
The 187.
All right, your plea deadline date has expired. The court will not accept any plea bargain agreements. The court will only accept pleas that are open to the court. Do you understand?
Yes, Your Honor.
All right, if there's nothing else, we'll close the record and you are excused.
Thank you, Judge.
Thank you, Your Honor. Have a
Thank
good
you.
morning, Charles.
All right,
Thank you.
Mr. Reyes, you can sign off. All right, Jonathan Watkins, you're back?
Yes, Judge, I'm back.
Yes.
And Your Honor, the state has actually, they're in the process of uploading some items to e-discovery, and they're going to make a hard copy of a surveillance video, Judge. And there are just maybe like 1 or 2 other things that we've requested that they're working on getting. If there's any way the court could recall us for like 3 weeks just to check back on the discovery compliance, that would be greatly appreciated.
All right, Mr. Sanders, if you're giving a 1-month reset, will you Is that enough time for the discovery and everything that needs to be uploaded and given to Mr. Watkins?
Yes, Judge, except for one thing we discussed, which is medical records, which we don't currently have in our possession. And I told him we would attempt to get, but that it may require them to do a subpoena.
Okay.
And so, but Jonathan and I will continue to discuss that off docket.
All right, thank you. Norma, on Obed Uridalis, could I have a 30-day reset, please?
Yes, ma'am. We can do the 20th, Judge.
All right, so we will come back on October 20th. Mr. Uridalis, you had your hand raised.
I was just acknowledging everything you said, ma'am.
Oh, thank you so much. All right, Mr. Watkins, if you don't have anything else, you're excused.
Just that you have a great weekend, Judge, and all your staff too.
Oh, thank you so much, Jonathan. Have a great Friday and a great weekend. Good bye to you, Mr. Uridalis. We'll see you back on October 20th.
Thank you so much, Judge. Have a beautiful weekend. And I just wanted to say I apologize for my appearance. I didn't know I had court, or I wouldn't have been in a t-shirt. I would have been in a collared shirt, ma'am.
Oh, thank you so much. I appreciate that, Mr. Uridalis. Have a great weekend.
You too, ma'am. Bye-bye.
Bye-bye. All right, Norma, do we have an update on Kevin Haggerling?
Let me check where he's at, Judge. Give me 1 second.
All right, thank you. Patrick Hancock?
Judge, yes, good morning, Judge. Thanks. I'm a little late, so I apologize.
No problem. Who do you have?
Judge, I have Wilson Daniel Jimenez, and if Mr. Nesbitt is available, I'd like to confer with him.
Okay. Okay, I will send you to breakout room number 13. That's a lucky breakout room.
Okay, thank you.
Nothing but good things have come out of that breakout room.
Well, I'm going to work on it. Try to continue to
Okay.
get straight. Thank you.
All right, everyone, let me just check my email to see if I received any paperwork. All right. Anyone else back from the breakout room? All right, everyone.
Yes, Your Honor.
Yes,
Your Honor, Sean Sheffield.
yes.
Your Honor, Meredith and I, we have discussed the case and we're mulling over an offer, trying to get some amounts on this. So we need a little bit more time if we could, Your Honor.
All right, do you know when, because today we're set for discovery. Do you know
Yes, Your
when you will have the amounts, or is there any idea?
No, not on that, Your Honor.
Okay, because the issue is we can't keep resetting for amounts.
I understand, Your Honor.
So I need,
Judge,
yes.
If you could just give us a couple of weeks, it's not, we are aware of what the amount of actual restitution is. It's more an amount for potential plea bargain that we're trying to come up with. And there's one additional item of discovery that was brought to my attention today that he does not have, that I am tracking down. We received this case from another unit within our office. And so I have emailed that prosecutor this morning.
All right, so if I were to give you a 30-day reset, would that be enough time?
It would.
All right, Norma, it's October 20th. Okay, I see that you've been giving October 20th.
Yes, ma'am.
All right, so we'll come back on October 20th.
Thank you, Your Honor.
Where's your client?
She's on, Your Honor.
All right, you're
On the
excused. We'll see you back on October 20th.
Thank you, Your Honor. Thanks, Meredith.
All right, and then David Cuellar.
And Judge, I'm sorry to interrupt. The inmate that you requested is on 17A.
All right, thank you. David Cuellar.
And
just one moment, Ms. Lefton.
I'm here, Your Honor. I apologize.
All right, I'm going to give your client the reset date. Your client needs to be on this Zoom next time if they're to appear. I understand that with the pretrial diversion, that means that the case is probably headed for dismissal, but your client needs to appear. Do you understand?
Yes, Your Honor.
I'm on Zoom now.
Thank you.
He just got on. I'm sorry, Your Honor.
All right, thank you, David. You've done great work to get him here.
Thank you.
All right,
He did
Mr.
great
Lipton,
work.
we're going to come back on your case on October 20th, okay? All right,
Okay.
thank you. You're excused. Thank you, Mr. Cuellar, for getting your client here. You're excused.
Thank you, Your Honor.
Laura Lefton.
yes, Judge, I conferred with Joel Ray, and we do have an offer. I'd like to get about a 45-day reset to talk to my client and see if he'll find it acceptable, and do the things we need to do before the next setting and hopefully have it resolved at the next setting.
Have you received all the discovery?
Yes, I have.
All right, Norma, on Falud Flores, can you give them a 30-day reset, please?
Yes, ma'am. I can do that one on the 21st.
All right, that's your plea deadline date. Will be
October
21st, yes.
Okay.
All right, you and your client are excused. Thank you for coming in.
Thank you so much, ma'am. I appreciate it. Have a nice weekend, everyone.
All right, thank you. You too.
Bye.
All right, so Matthew Allen, and then we're going to take up Mr. Haggerling. Matthew Allen?
Yes, Judge. I conferred with Marcus. He did make an offer. Mr. Simmons does not want to accept it, so we'll need a trial setting.
Well, before you get a trial setting, I have to give you a plea deadline date. So just give me one moment.
Okay.
Where is Mr. Simmons?
He should be on the Zoom. I just talked to him on it.
Mr. Simmons?
I'm right here, ma'am.
All right, good afternoon, good morning.
Good afternoon. Good morning to you, ma'am.
Sometimes it seems like it's in the afternoon, but we're not at 10 o'clock
I
yet.
don't know what it is today. It's just crazy. I tell you that.
All right. So Matthew Allen, you received all the discovery in this case?
Yes, Judge.
All right. So Mr. Simmons, in this court, I give everyone a plea deadline date because I don't want anyone to receive an offer the day of, and then I'm telling them they need to make a decision the day of.
Yes, ma'am.
All right. I want you to have a chance to think about it, and whether you accept it or not is completely up to you. All right.
Yes, ma'am. I appreciate that.
All right, Norma, can I give a 30-day reset on Daryl Simmons, please?
Yes, I'll do it on the 21st.
One clarification, Your Honor.
Yes.
At that 30-day, then we come back and then we can go ahead and ask for the trial date. Then is that what that happened? Okay.
Yes.
Yes, ma'am.
All right.
Thank you so
Norma?
much.
Sorry, Judge, the 21st.
All right, so we're going to come back on the 21st, and let me explain to you, Mr. Simmons, what will happen on that day.
Okay. Yes, ma'am.
All right, that is what's called your plea deadline date.
Okay.
So between now and then, you speak to your attorney. Your attorney will tell you whatever he needs to tell you.
Okay.
You will come back on that date, and on that date, you will let the court know whether you're accepting the agreement or not. If you decide not to accept it, that's fine. And then on that date, I will give you a jury trial date. Do you understand?
Yes, ma'am.
But after that date, the court will not accept any plea bargain agreements. The court will only accept agreements open to the court, okay?
Yes, ma'am.
All right, thank you, Mr. Allen. If you don't have, do you have anyone else with us?
No, Your Honor.
All right, you're excused and your client excused. Have a great weekend, great rest of your Friday.
God bless.
Oh, thank you. God bless you too.
Yes,
it's nice to receive blessings.
Yes, ma'am. Thank you. Bye-bye.
Bye-bye. All right, so we're going to take up Mr. Haggerling's case.
Out of there.
Brenna, are you ready?
Ready.
Okay. Who's the prosecutor is Joe Ray. Mr. Haggerling, you need to start your video. Norma, can you see what is happening because there's no video?
Yes, ma'am.
All right. Mr. Haggerling, can you unmute for me, please?
Yes. Yes, Your Honor.
Were you sworn in by the clerks yesterday?
Yes. Yes, Your Honor. I was sworn in by the court right before we left.
Okay. Joe Ray?
Yes, Judge.
You email, oh, I have it, sorry. I was like, are we missing something? No, we're good. All right, the court is calling 2021 CR 8212, State of Texas versus Kevin Haggerling. Can I have parties announced for the record for the state?
Joe Ray Garcia.
For the defense?
Anita Perez Garza for the defense, Your Honor.
Right, and the court is also calling 2019 CR 11098, State of Texas versus Kevin Haggerling. And are you Mr. Haggerling?
Yes, Your Honor.
And each of these cause numbers, we're proceeding by video because of the pandemic. Any objections from the state?
No, Your Honor.
Any objections from the defense?
No, Your Honor.
Mr. Haggerling, in each of these cause numbers, I'm showing you what's entitled Defendant's Consent to Appear by Video Conferencing. Did you review those documents with your attorney and did you understand them?
Yes, Your Honor.
In each of the cause numbers, the court will find that defendant has knowingly and voluntarily consented to appear by video. We're going to proceed first on cause number 2021 CR 8212. And everyone, just give me a moment.
Hold on, Judge. I lost connection.
Yes, I know. I saw. It's like, it's not coming out on my screen anymore.
Okay, it should be back.
Yes, thank you. All right, in that cause number, defense, I'm showing you what's entitled Discovery Acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Haggerling, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
State is proceeding on count one, waiving count two.
Any objections?
No objection.
Mr. Haggerling, I'm going to show you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
What you're charged with in count one is assault, family choking, strangulation second. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call them the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses for this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I believe he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Haggerling, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Absolutely, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Next, I'm going to show you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, the state is proceeding on count one only. Punishment is to be assessed at a cap of 4 years in the prison. There are no applications. This is run concurrent with the motion to revoke cause number 2019 CR 11098. State will take in consideration the following NIMAC numbers: 627956, 627954, and 2021 CR 8213. There's an affirmative finding of family violence. There's to be no contact with Myrna Alcantara. Did you understand with the affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, Your Honor.
Did you understand with the affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, Your Honor.
Did you understand that to be the entirety of the plea bargain agreement?
Yes, Your Honor.
Defense is at the plea bargain agreement.
Yes, Your Honor.
State is at the plea bargain agreement.
Yes, Your Honor.
Next, I'm showing you the paragraph entitled waiver of appeal. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Then to the offense is charged in count one. How do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence to support the defendant's guilty plea.
State offers State's Exhibit 1 and all its attachments.
Any objections?
No objection.
Mr. Haggerling, I'm going to show you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor. Well, yes, Your Honor.
Anything you wish to say on behalf of your client?
I guess just a procedural point, Your Honor. This is to run concurrent with the MTR, so
Yes.
So I'm assuming that the court's going to hear this first and then the MTR.
No, I'll make a ruling on this case if you all are proceeding with sentencing, and then whatever happens in this case, yes, this case will run concurrent with the motion to revoke.
Okay, so I guess that's where I'm going, Your Honor. Okay, can the court give me like 30 seconds?
Yes.
I need to move my location. I didn't realize how sunny it was, and I'm like, so I'll, if I can come back in 30 seconds, Your Honor.
Sure. Yes.
Excuse me. Your Honor, while we're waiting, can you put, let me look on here, Wilson Daniel Jimenez in a room with Pat Hancock, please?
All right, and what Pat Hancock, I remember, is in 13.
Yes.
Is Jimenez, yes, he's in custody.
He's in custody, Your Honor.
Okay.
Tom, did we want to
Just
go
one
ahead and give the
second.
judge an update or and that way when I'm done, I'm done?
She's gonna want him to come back out of the breakout
Oh, okay.
room to the lobby though.
All right. Then I'll go to 13.
All right,
Yeah.
I sent him to 13.
Thank you, Judge.
You're welcome.
Okay, I'm back, Your Honor. I'm so sorry.
All right. Is there anything you wish to say on behalf of your client?
Well, yes, I'd like to call my client, Your Honor. If the court can, if the court wants to swear him in.
All right, then if you're going to call him as a witness, then yes, let's hear his plea on the motion to revoke. And then that way his testimony will count for both hearings. The court is going to proceed in 2019 CR 11098. Mr. Haggerling, I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. First amended motion to enter adjudication of guilt and revoke community supervision. And third amended motion to enter adjudication of guilt and revoke community supervision. Did you review those with your attorney and did you understand them?
Yes, Your Honor.
Are you the same Kevin Gennaro Haggerling who was placed on deferred adjudication in 2019 CR 11098 for the offense of assault, family choking, and strangulation on November 26, 2019 for a period of 5 years and extended for a period of 2 years? Is that you?
Yes, Your Honor.
All right, state.
On the first amended motion to adjudicate probation, violated condition number 1, on or about the 4th day of July, 2021 in Bexar County, Texas, the defendant, Kevin Gennaro Haggerling, committed the offense of assault in violation of condition number 1.
How do you plead to that, true or not true?
True.
State waiver counts.
Any objections to the state's waivers?
No, Your Honor.
Mr. Haggerling, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine? Did you understand?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 1?
Absolutely, I plead true.
Court would find violation of condition number 1 true. Defense, you wanted to call Mr. Haggerling as a witness, is that correct?
Yes, Your Honor.
Mr. Haggerling, if you could raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. Defense?
All right. Mr. Haggerling, can you tell the court how old you are?
27 years old.
Okay, and do you have any prior felony convictions?
No.
Okay, and are you currently taking any medications right now?
Yes, I'm on medication for bipolar disorder, anxiety, depression, and PTSD.
Okay. Now, you've picked up a lot of cases regarding Myrna. Is that right?
Yes, ma'am.
So can you tell me, I guess specifically, the most recent one from August of 2021?
Just one moment, please. Mr. Cruz, I need you to go to breakout room number 1, and could the clerks go to breakout room number 1 to swear in Mr. Cruz? All right, you may proceed, Ms. Pettis. Sorry about that.
Yeah, no, it's fine, Your Honor. So on the, when you picked up the new offense, can you tell me what was going on? Because obviously you were on bond. So I just want you to clarify for the court what's happening.
I had just, there had been a bit of a mishap. I had woken up taking my medication for anxiety and everything. And I ended up having an anxiety attack before the medication had kicked in on that day.
Okay. And the police were called.
Correct.
And can you tell me, I think there were several statements that were given from your father. Can you tell the court, if there was any issues with the truthfulness of any of that going on?
My father has a bit of a memory problem. He has dementia, And so he kind of gets things mixed up. And whenever he's getting in a stressful situation, he kind of jumbles his words and such. So yes, the things were mixed up when he was talking to the police that day.
Okay. So, but you are not trying to tell this court that you, that there wasn't an altercation between you and Myrna, right?
Correct.
So in other words, as a point of clarification, I think, is there anything you want to tell the court about that particular day?
That particular day, I was just having a really bad anxiety attack. I am given medication to take so that I cannot, so that I do not have the episodes, the manic episodes. And I had.
You can continue, Mr. Haggerling.
Oh, I'm sorry. Yeah, and so I do have medication to take, so I do not have the manic episodes. I had just woken up when everything had happened, or I had just woken up and taken my medication that morning when everything had occurred. The medication literally had kicked in right when the police officers had showed up that day. I use the medication is actually a good help so that I don't have the manic episodes. It's just, it was a roll of the dice type of a thing. I wasn't, again, because I had just woken up in the morning. I believe that a lot of these, all of these cases that I have had have a lot to do with the fact of the anxiety and the bipolar depression. In 2018, I had lost my mother, and that's when everything had more or less started with all of this. And I finally had gotten help with Center for Healthcare Services recently and been able to start getting treatment so that this wouldn't happen. But here we are today.
Yes, and in fact, prior to you having this altercation, the subsequent altercation with Myrna, I believe the recommendation from probation was for you to do mental health probation. Isn't that right?
Yes.
And that's why you were attending the Center for Healthcare Services. Isn't that correct?
Yes, they had told me that I'd been referred to Center for Healthcare Services actually a month or so after I'd actually been put on the initial probation that I'm being revoked on today. But it was a waiting list of like 6 to 8 months. And then I had been going in on suicide watch and stuff and such with 72-hour detention through Bexar County. Well, I had, when I was released on bond the last time, I had actually been put on suicide watch again. And then I finally took myself to Center for Healthcare Services and I told them that I really needed the help, and they were able to push me through after I had already spoken with probation about being put on the MIC. The lady that I had spoken with had told me just try to get there as early as possible. And so I was able to get my GPS officer to be able to let me get out there at 6 o'clock in the morning so that I could actually stand in line and get in there and get the help and get the medication that I needed. And so I could start therapy as well.
Right. And so prior to all these assaults, so what were you doing for a living?
Prior to all of this, I was working, but for all these assaults, I was working construction for myself and then for another company. But I actually started working for my own little business doing remodels, small remodels and stuff like that during my time on probation.
And so at this time, we're looking at a cap of 4. The minimum is 2 years. Is there anything you want to tell the court? Obviously she's heard about your mental health issues that's something that it's kind of transpired in the last 3 years. Is there anything else you'd like to tell the court?
Yeah, I would like to ask the courts just to understand. I did ask for the help with my probation officer. I did ask my probation officer for help with this. It had just taken a while because I didn't, CPS was actually the one that initiated me getting the mental help. And I didn't know that was something possible, but I guess it was also my fault for not asking for the help through probation. But because of the weekly check-ins, I was able to, I had asked Miss Rodriguez, who was my probation officer at the time, if she could help me with anything with mental health because I was considered low income. So, I mean, I understand what the range of punishment is in the sentence and that this is sentencing for prison, but I just wish that we could maybe try one other option with the MIC probation because I feel that would help. And I've already initiated trying to get the help myself. I just wish I could get one more opportunity.
And how many children do you have, and who is that with?
I do have two children, one deceased, the other one is almost going to be a year next month actually. And that's with Myrna. The youngest is going to be with Miss Alcantara.
This is the victim in this case. I see that your brother is here in court today. I don't know, can I call his brother, Your Honor? His name is Eric Haggerling.
No, just one moment. State, do you have any questions?
Yes, Your Honor. May I proceed?
Yes.
Mr. Haggerling, let's start off with the case you've been on probation for. This isn't your first or second motion to revoke, is it?
No, I want to say this is my third motion to revoke, sir.
Right, your third. And on your last one, you were given the chance by being extended 2 more years on probation, right?
Correct, sir.
Okay. And as your defense attorney said, and then you stated, you picked up a lot of assault charges against one person, right?
Correct, sir.
And that's Miss Alcantara?
Correct.
Okay. Now let's turn your attention to July 4th, 2021. That's the violation of condition number 1 that you just pled true to. Do you remember that date?
Yes, sir.
Okay. And on that date, you attacked and assaulted the complainant, Miss Alcantara, right?
Correct.
And you showed up to her home, is that right?
Yes, I was dropping things off for my son. Yes.
Okay, and you're uninvited? Is that a yes?
Yes.
Okay. And when you showed up, she wanted you to leave, is that right?
Yes.
And you got on top of her and pushed her down?
Correct.
And you choked her using her own purse?
Correct.
And during this time, you were stating a lot of things to her, weren't you?
Correct. I have blackouts during those anxiety attacks, and so yes.
Okay. And eventually, do you remember the police were called?
Yes.
And you ran from the police, is that right?
Yes, I left the place. Yes.
Okay. And were you
I was actually trying to leave before the police got called, to be exact.
Okay. And you were eventually found by the police, right?
Correct.
And were you tased during this time?
Yes, 3 times.
Okay. And were you trying to hide from them before that?
Yes.
Okay. Now let's talk about the most recent one on 8/23. How did you come in contact with the complainant?
My father had been speaking with her because there had been a mix-up with the phones, and then I was just trying to get to the bottom of it, and so I had contacted her, actually, as well.
Okay, by a mix-up with the phones, you mean that you were texting from your father's phone?
I did not actually have my phone in my possession. She had my phone in her possession. I guess my father had messed up or given it to her with a bag of stuff for my son that day, or the day before. And so I was just trying to get to it because I needed it for GPS, probation, so on and so forth. So yes, I did use my father's phone.
Okay, and Ms. Alcantara has contact with your father, right? She speaks to him normally?
Yes, she does.
And they have a relationship because of the family, because of his grandkid?
Because of my son, Ezekiel, yes.
Okay. And let me ask you, you talked about mental health and eventually you got some help with it. When was that?
The date, it would actually, I don't know the exact date, but it started 2 days after my release this last time. So the last time I was released from jail, I can't tell you the exact dates without having a calendar in front of me.
Okay, but you can't tell me it was before this last assault. Is that right?
Yes, it was. I started right before this, before this last case. So I was released on bond on leg monitor, and that's when I started. I went to San Antonio Behavioral Health and then started with Center for Healthcare.
Okay, and before this last assault on 8/23, you were actually in court 2 days before that, is that right?
Correct.
Okay, and that day you said that you were sick and you got a reset for this case?
Yes, it was because I was having a bad reaction to the medication for anxiety attacks for the same medication that I had taken the day that the 8/23 case had happened. I was just having a bad reaction that day.
And it made you ill?
Correct.
Okay, but not ill enough not to assault her 2 days later?
The medication kicked in right when the police had already showed up. In the video, the officer was actually having to pick me up and carry me around because I was falling all over myself from the medication. It basically incapacitated me.
You were incapacitated, but you're still able to assault.
When the medication kicked in.
Objection asked and answered.
That'll be overruled.
So that
you can answer, Kevin.
When the medication kicked in, it had been when the police had arrived, but I had taken the medication before she had arrived before she had actually even gotten there.
Okay.
But it just took a little bit for the medication to actually take its course on me, if that makes any sense.
Okay, no further questions, Judge.
All right, any follow-up, defense?
Yes, Your Honor. Mr. Haggerling, so have you heard of, so was it the Access program that they were having you do?
Come again? It's kind of loud in here.
Yeah, it's loud in here. I apologize. Is it the Access program that they were trying to get you in, the mental health?
It was
Center for Healthcare Services?
I think so. It was Mick. It was like it was a special probation. I don't know exactly what it was called, but they did put the referral in.
Okay. And so it was going to address thinking errors and decision making, right? That
Correct.
was okay. Okay. And how long have you been on the medication for the anxiety? How long have you been taking it?
I started taking it. 2 days after they put me on it because I went on that. I knew I needed the help, so I went on that suicide watch. So like 2 days after.
Okay, but is it like in May of this year, June of this year? You know what I mean? Like
July.
3 years ago? Okay, so
July.
you had just started. So there was still, where the doctor still needs time, to adjust the meds accordingly. Isn't that correct?
Yes, ma'am.
Okay. Okay. Let's see. And how long had you been seeing the psychiatrist through CPS?
We had one initial meeting, and then they were going to follow up with me, but my caseworker did change. And then there was communication issues. Plus, I was not stuck, but I was here in Bexar County and so on and so forth. But I did meet with them.
Okay. And so in essence, I guess you were no longer a continued threat because you were no longer living with Ms. Alcantara. Is that right?
Correct.
Okay. And prior to committing the offenses, you were living with Mirna Alcantara. Is that right?
Correct.
And while you were on bond, that's when you went to go live with your dad. Isn't that right?
I never lived with her. I wasn't living with her. I was on.
Objection leading.
Yeah,
That'll be overruled. You can ask the question.
So Mr. Haggerling, I'm just trying to give the court some perspective. So you were living with Ms. Alcantara prior to all of this.
No, I was having to stay with my father because we were not supposed to be together because of the no contact.
Well, I understand that, but I'm asking about before.
But before, yes. Before, yes.
Okay. Okay. I don't have any other questions, Your Honor.
All right, any follow-up, state, any recross?
No, Your Honor.
All right, defense, call your next witness.
If I can call Mr. Eric Haggerling.
Mr. Eric Haggerling, I need you to show your video, please. All right, if you could raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand. State your name for the record, please.
Eric Anthony Haggerling.
And could you spell your first name?
E-R-I-K.
All right, defense.
Yes, Your Honor. So Mr. Haggerling, can you tell me your relationship to Mr. Haggerling?
Well, he's my brother.
Okay. So is there anything that you want to tell the court on behalf of your brother?
I do. I know that Kevin's had a lot of issues over time. We didn't have the best upbringing as far as, I don't really know how to explain it, as far as, you know, general home life wasn't great for us as kids. He had a lot of issues growing up, especially in his early adulthood. But over the last few years, I've seen him fall down and then start picking himself back up. He's made strides in taking better care of himself, better care of his mental health. He's actually seeking help, which is something that took a lot of support from us. And that's what we do. My wife, my brother, and my dad were kind of his support system in this situation. We've all been encouraging him to make better choices and to seek the help that he needs. And from my understanding, mental health care is very expensive, and not having a lot of money is a huge barrier to getting what I believe is a very necessary service. My wife is in the mental health profession as well, and she's well aware of the tribulations of somebody on the lower socioeconomic level trying to get help when they need it. And so when I found out that he was going to the various programs that the city and the state are offering, I was really happy to find out that, you know, we're actually taking care of people these days as opposed to just throwing them in jail and letting them get worse. Because I mean, I've never been in jail and I hope never to be, but I do know that the situation in there is not conducive to recovery, especially when somebody has gone as far as he has to help himself. And I just find that him ending up in jail is going to be more of a negative than a positive. I just want him to be able to continue to get the mental health care that he needs so that someday he can become a good father to his son and a good upstanding citizen.
Any further questions?
No, Your Honor.
State any questions?
Just briefly, Your Honor. Mr. Haggerling, you stated that your brother started picking himself up because he started to get help with his mental issues?
Yes, he did.
Okay, well, are you aware that he picked up another violent offense after the fact, that once he started getting help?
I am.
Okay, and you're aware that he has several violent felony offenses pending against him?
I am.
Okay. No further questions, Your Honor.
All right, any redirect?
Your Honor. No, Your Honor.
All right, Mr. Haggerling, thank you for coming in.
Thank you.
All right, any other witnesses from the defense?
No, Your Honor.
State any witnesses?
No, Your Honor.
All right, the court will hear argument in cause number 2021 CR 8212 and in cause number 2019 CR 11098. And cause number 2019 CR 11098. Is there an agreement on punishment?
Judge, it's the same agreement. We're asking for the cap of 4 as the plea case.
All right, Mr. Haggerling, in cause number 2019 CR 11098, are you asking the court to follow the agreement that's been reached to a cap of 4 years in that cause number?
Yes, Your Honor.
Are you waiving your right to appeal?
Yes, Your Honor.
All right, then the court will hear argument. State.
Judge, in this case, we are going to ask for the 4 years on the cap. Reason being, while on probation, given 2 prior chances, he continued to pick up violent offenses. Not just 1 or 2, but several. He pled true to a new offense and also pled true to a different number 1. As you heard during testimony, these offenses occur not because of the complainant willing to break a no contact order, but because she unknowingly ran into the defendant because he planned on it. He stated a lot of things about having mental health issues, but he can still continue to pick up violent offenses. 4 years is a more than reasonable request based off all the facts and all the new offenses and assaults that the defendant has committed.
All right, defense.
Yes, Your Honor. So our response to that is, unfortunately, the sequence of events happened very, very quickly, just like Mr. Garcia stated. Mr. Haggerling was in the process of getting mental health treatment. We're not trying to, deny that any of these events happened, Your Honor. My client did state that he gets into a mental state where he doesn't realize what he's doing. The person that didn't testify today, the victim in this case, recognizes that he needs mental health. She knows that he is a good father, and she acknowledges that he needs help. He's 27 years old, Your Honor. This is not like a typical case where, we can just kind of, everything goes perfect, everything goes smoothly. In this type of case, he really needs mental help. But because he picked up these subsequent offenses, we had no other choice but to accept the cap before. I would hope, Your Honor, I understand that he'll be free from probation, because that's not our agreement, but, I would hope that if the court takes in consideration the fact that he does have mental health issues, Your Honor, that he'd be looking at the minimum and that he would that he would take himself to for mental health after all of this is done, because clearly he does need help. I don't think it's fair, for someone that needs this type of help to just go to jail, and just do the time and then get out. He needs frequent supervision. I would hope that he gets independent treatment after he gets out, Your Honor. That is the hope that we would want, but he doesn't belong in prison. He's 27 years old. He doesn't have any prior felony offenses. He was on deferred. That's what we were under, Your Honor. So I would ask your mercy in this case, Your Honor, and you would give him the minimum.
All right, nobody thinks they belong in prison. I mean, that's what everybody says. I don't belong in prison. I guarantee you, everybody there says they don't belong in prison. But what I do know is everybody who's placed on probation out of the 187 District Court, Mr. Haggerling, and you know this, when I give you conditions, I always ask probation. Probation, is there anything else that this person needs? And then I ask the defendant, is there anything else that you think that you need that we can help you with? And you had a previous motion to revoke for the assault family choking. And at that time, when I continued you, I know I asked you, is there anything else that you need? I denied it. And that was for picking up a new number one case. So number one, and all the motions to revoke, when it says a new number one, or there's a number one is a new offense has been committed. So at that time, and it's noted here on August 3rd, I found it true, denied the motion, asked, was there anything else that you needed? Anything. Then we came back on February 23rd, there was a new number one. Found it true, extended for 2 years, asked, and I know I asked you, was there anything else that you needed? And it was altered and amended to include cognitive behavior and moral conditions, And I took into consideration another felony case, which was 2020 CR 1199. And it was to do weekly reporting in parenting classes. And Mr. Haggerling, what I want you to understand, you can't be a good parent if you're being abusive to the mother of your child. I know people will say, but I'm a good parent. No, because you're bringing violence into the home. And I guarantee you, people think, children don't know. Yes, they do know. And children can feel the tension in the room, and that impacts a child's mental health, physical health, and emotional health. And children, as I always tell everybody, how children learn to speak? By listening to people. That's really how they learn. So when you have a child who's using profanity and people are laughing at that, which I don't find to be funny, what that means is people are speaking profanity around them. When you have children who see physical abuse in their house, one or two things happens. If it's a son and their father's abusing the mother, they think that's the way you show love. If it's a daughter and they see the father abusing the mother, they think this is how you show love. And the other thing they think is, you want to win an argument, you need to be the strongest one, and you need to win an argument by being abusive. So people come to me and they say they have mental health issues. When they do, guess what? McMile, it's free. So I've given you help. Now, once I give people the help, whether or not you take it, whether or not you accept it is completely up to you. And I tell everyone who has a mental health issue, if there's a problem with your medications, let your doctor know. The doctor doesn't know if you're experiencing side effects if you don't let them know. One thing I do know, whether you have anxiety or not, I ordered that there was to be no contact with Myrna Alcantara. Can you imagine the fear she feels? Because in each one of these cases, it's choking. Choking is up close and personal. Do you know how it feels to have somebody choking you where you can't breathe? So in 2019, CR 11098, the court will find you guilty, not grant you community supervision, sentence you to 4 years in the prison, give you credit for any time served. There's to be no contact with Myrna Alcantara, permanent finding of family violence. This will run concurrent with 2021 8212 and 2021 CR 8212. The court will, as previously stated, find you guilty, sentence you to 4 years in the prison, give you credit for any time served. There's an affirmative finding of family violence that will run concurrent with 2019 CR 11098, taking in consideration NIGHTMAG number 627956, 627954, 2021 CR 8213, and there's to be no contact with Myrna Alcantara. When you're released on parole or released from prison, do not have any contact with her. And if you want to be a good parent, and I previously saw where I had ordered parenting classes, take some parenting classes. At some point in your life, if you get your life together, if you're no longer violent, things may change. And each of the cause numbers, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review those documents with your attorney? Did you understand them? And did you electronically sign them?
Yes, Your Honor.
And each of the cause numbers, because it was a plea bargain agreement, because I followed your plea bargain, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Mr. Haggerling, good luck to you. I know, 4 years seems to be a lot of time, but it's not the end of your life. We're all on a journey in life, and hopefully we will improve as we go along. All right, good luck to you, Mr. Haggerling.
God bless you.
Oh, thank you. God bless you too. Norma, you can let 17A go back.
Thank you, Your Honor.
Yes, ma'am.
You're welcome. All right, who are the parties on Edward Ramirez?
Your Honor, we're ready on Mr. Ramirez.
And who is the prosecutor?
Marcus Sanders.
And I'm trying to find your client, Miss Benavides.
He's in the courtroom, Your Honor.
Thank you. All right, to the courtroom, if you could have Edward Ramirez come forward, please.
Yes, Your Honor. Right here between the arrows, just look forward, sir.
All right, Mr. Ramirez, do you need to have a seat or are you okay standing?
I'm all right for right now. Thank you.
All right, if you need a seat, just let the deputy know. We have chairs in the courtroom. All right, the court is calling 2021 CR 8399W, State of Texas versus Edward Ramirez. Can I have parties announced for the record, please, for the state?
Marcus Sanders.
For the defense?
Alma Benavides.
And are you Mr. Ramirez?
Yes, Your Honor.
We're proceeding by video, but because of the pandemic, the court will note for the record that Mr. Ramirez is in the courtroom. Any objections from the defense?
No, Your Honor.
Any objections from the state?
No, Judge.
Mr. Ramirez, I'm going to show you what's entitled Defendant's Consent to Appear by Video Conference. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled Application for Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
All right, just one moment, everyone. We're back on the record. Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Ramirez, I'm going to show you a document entitled Waiver of Indictment, Reading of Information, and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor.
Did you understand you have a right to have a grand jury hear the evidence in this case and make a decision on whether or not to indict? And your attorney also has certain rights, namely 2 days from the presentation of the information and 10 days from the presentation of the information to prepare for trial. Did you understand?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived indictment, reading of information, and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Mr. Ramirez, I'm going to show you what's entitled Information. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the information?
Yes, Your Honor.
State, are you proceeding on the information as presented?
Yes, Judge.
Mr. Ramirez, I'm showing you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Did you understand what you're charged with is theft under $2,500 enhanced? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do.
Do you believe he's currently competent and is legally sane at the time of the offense?
Yes, Your Honor.
Mr. Ramirez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Next, I'm going to show you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, punishment is assessed at 1 year in the state jail facility. There's a $1,000 fine probated. There's no application for deferred adjudication. State recommends community supervision. There's to be no contact with HEB at 4100 South New Braunfels. Did you understand that to be the plea bargain agreement?
Yes, Your Honor.
Defense, is that the plea bargain agreement?
Yes, it is, Your Honor.
State, is that the plea bargain agreement?
Yes, Judge.
Next, I'm showing you what's entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement, the state is requesting that your community supervision be for a term of 2 years. There be 80 hours of community service restitution, CATs 1 and 2, and a TAP evaluation. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged in the information, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence to support the defendant's no contest plea.
Yes, Judge. The state offers State's Exhibit 1 and
Any objections?
No objections, Your Honor.
Mr. Ramirez, I'm going to show you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same.
Your Honor,
I'm in a hearing.
I'm sorry, couldn't tell.
All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, we're asking the court to follow the plea bargain agreement. Mr. Ramirez is 59 years old. He has spinal scoliosis. He's blind in his left eye. He tells me that he has L4 and L5 discs that are ruptured. He gets around with a walker. He receives disability, $794 a month, and he's also receiving $198 in food stamps. We would ask the court to probate the community service in light of the fact that he does have these physical limitations. And we're asking the court to go along with the plea bargain agreement. He does not have an email address. He does not have a computer. So I have told him that if the court were to order that he take these classes, and if they are offered online, and that's an option for him, that he's going to need to find the use of a computer, borrow a computer, that he can satisfy that requirement.
Okay. Mr. Ramirez, why are you stealing? And the items that you stole, it's not food. It's not a necessity. I can wrap my mind around someone stealing food. Maybe they don't have food. Maybe they don't know that there's a Sam's or places for you to get food. Maybe they don't know there's a food bank in existence. But you're stealing electronics. You're riding around in a scooter, stealing electronics. And this is not the first time you've stolen. Your criminal history is riddled with thefts. Why do you keep stealing?
Your Honor, it's like I was telling my attorney that I don't know why, ma'am. It was out of stupidity.
Well, I mean, it's not out of stupidity. How old are you?
59.
I'm sorry, what?
59.
All right, so you're 59. Everybody was taught not to steal.
Yes,
You're not
ma'am.
stealing food. You're not stealing diapers. You're rolling around in a grocery store, in a scooter that the grocery store provides, and you're going around stealing. So is there something working upstairs?
I don't know why, ma'am. I don't have an answer for that, a complete answer, an honest answer. The thing is that like when I go to the store, I don't know. I just have to get something from my pocket.
Okay. Probation, is there a class? I don't know if this is kleptomania that's happening here. I don't know if cats 1 and 2, we can say cats in 1 and 2. I don't know if there's a mental reason for his stealing.
I think the closest thing to that would be the felony theft course, but I mean, I don't know if that would address his.
So would the felony theft course address it better than cats 1 and 2, or should it be cats 1 and 2?
We can go with cats 1 and 2 if we need to go further than that, Judge. Sounds like he knows the issue. It's a compulsion thing, but I don't know.
Okay. Have you ever had employment, Mr. Ramirez?
When I was younger, yes, ma'am.
All right. Are you receiving SSI or anything of that nature now?
SSI only, ma'am.
All right, this is what the court is going to do. Sentence you to 1 year in the state jail facility, suspended and probated for 2 years, $1,000 fine, that'll be probated. You to do regular reporting by Zoom or in person. The 80 hours of community service restitution, I will probate that based upon your attorney's representation to the court. Cats 1 and 2, proof of SSI within 20 days or employment within 20 days. So if you provide proof of SSI, you won't have to be employed. But if you don't provide it, you're going to have to be employed. And there should be no employment as a home health care provider or any employment with minors. There should be regular UAs. We're going to do field visits 1 time per month. And Mr. Ramirez, I know people don't like people coming to their homes, but I'm going to have probation come out to your home to make sure that there are no items that should not be there that have not been paid for. You understand?
Yes, ma'am.
Kevin, is there anything else he needs?
No, Judge, I think we've addressed that.
All right.
And we have the no contact, correct?
Yes, I'm doing that right now.
Okay.
There's to be no contact with HEB at 4100 South New Braunfels. HEB no longer wants you there. If you go there, there's going to be a criminal trespass issue, and most definitely you will have violated your probation. Do you understand?
Yes, ma'am.
All right. Anything else that you need from the court in order to be successful, Mr. Ramirez?
No, ma'am.
I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, Mr. Ramirez, good luck to you. I'm going to have you take a seat, and probation will be with you shortly. Just take a seat. Kevin, we have another case that's coming up that's a probation case, and they're in the courtroom as well, so just give me a moment. Ms. Christian, can you start your video?
I'm here, Judge.
Yes, what is happening with your case?
So I have conferred with Mr. Martin, and he very kindly has made or is going to make some discs of discovery available to me by probably the end of next week. He and I are in email contact with one another about getting this discovery done. And then I may have to file some additional motions if there's other discovery issues that come up, but otherwise that's what's going on. So we just need a reset from the court.
All right, Norma, can you give me a 30-day reset on Mario Guerra?
Yes, ma'am, the 20th, Judge.
All right, so we'll come back on the 20th to see where we are with the discovery. And you say things just need to be uploaded, and there are other things I guess you need to view in person?
Yeah, it looks like that, Judge. That's what it's looking like, yes. So October 20th, do I have that right, Judge?
Yes, October 20th.
Okay.
All right, and is your client in custody or on bond?
He's on bond and he is on the screen, Judge.
All right, you and your client are excused.
Thank you, ma'am.
Thank you, ma'am.
Thank you. Have a great rest of your day.
You as well.
Thank you. Alma, you have your hand up?
Yes, Your Honor, I just wanted to excuse myself, and I hope you have a safe and restful weekend.
Oh, thank you so much.
Good to
Have
see
a
you.
great
Take care.
All right, you too.
Thank you.
All right, Ed Bartolome. All right, Ed Garza.
Present, Your Honor.
Yes,
My
who do you
client, I
have?
believe, is in the courtroom.
Who's your client?
Gracie Marie Sandoval Cruz.
All right, and the court has the paper. Oh, no, I have Noah Cruz.
No, Your Honor. My
Here's
client was
Gracie.
going to try and pay off the amount of money that she was in arrears, but I believe she's only able to maybe come up with part of it.
All right, this is what I'm
Otherwise,
gonna do. I'm gonna send you to a breakout room with probation, with someone from the state.
I've been, Marcus Sanders, I've been discussing it with him.
Okay. Let me send you to a breakout room. I'll send you to breakout room number 2.
Yes, ma'am.
Eddie Bravenant.
Hey, Judge. I have Lindsay Phillips on today's docket. I left Miss Phillips in the breakout room, and I would not normally do that, but I don't know if you remember, she has some, she's developmentally slow. Okay. So she literally can't speak to me today, and I can't tell if she's having a bad day or if I need to have her evaluated again. I was going to ask the court to
evaluation. Do you need another evaluation or no?
Well, what I was going to ask the court to do is set me for next Wednesday, and at that point determine, was she having a bad day or do I need to have her evaluated? Would you be willing to do that?
Yes, of course. Norma, can we recall Ms. Phillips for Wednesday? Is that doable?
Judge, I just put something in the chat, but yes.
Okay, yes. And Norma, can you chat that to Mr. Bravenant as well, please?
Yes.
All right, so we will bring her back on the 22nd.
Where's Eddie at? Oh, here.
Norma, I'm trying to find it, but I'm not doing a very good job.
I'm typing right now. Hold on, Eddie.
All right, and Norma Phillips is L20.
Yes, ma'am.
Okay, good.
All right, Eddie, have a great rest of your week.
Yeah, all right. So let's thanks, Judge.
right.
Let's try next Wednesday. I appreciate it.
All right, thank you so much. Have a great rest of your day. Do you want to go back and speak with your client, or if not, we'll just have someone excuse her from that room?
I think for that reason, it makes no sense. I don't need to speak with her. I'll try next Wednesday.
All right, thank you. Have a great one. Norma, she's L20.
Thank you,
Judge.
All right, Raymond Martinez.
Judge, I've conferred with the state. We still have the same offer on the table on Patrick Samaniego. And although the state is waiting for one other bit of discovery that might have some impact down the road.
All right, just one more. Well, who were you conferring with?
Hunter Morris, Judge.
All right, Hunter, do you know when you will have this discovery that you're waiting for?
Judge, it's video for the troopers that made the arrest, and I had hoped to have had it by now, so I sent a reminder. If I don't have it in the next few weeks, Judge, then I'm just going to proceed on the case as currently.
All right, so what I'll do then is I'll set this for a discovery, Mr. Martinez, to see if we have that in. Norma, can I have a 30-day reset for discovery on Samaniego?
Yes, we'll do the 20th as well, Judge.
All right, so we're going to come back on the 20th
Okay.
of October.
Thank you, Judge.
All right, Mr. Martinez, if you don't have anyone else with us, you are excused and
I
your
do not,
client is
Judge.
excused.
Thank you, Judge.
All right, thank you. Patrick Samaniego, you're excused. Pat Hancock.
Judge, I conferred with Mr. Nesbitt. I think we're working on, or he's working on some additional discovery with a co-defendant to give to me. And we're trying to get where we can have some plea talks. So a reset would be nice, and my client's in custody on the screen.
All right, Norma, can we have a 30-day reset? And you say this is discovery, correct?
Yes, ma'am.
All right, Norma, on Wilson Jimenez, can I have a 30-day reset?
Yes, ma'am. I'm going to push that one for the 25th, Judge, which will be on a Monday.
All right, we'll come back on October 25th.
Thank you, Your Honor.
All right, thank you. You're excused. Norma, can you let them know 16D, Mr. Jimenez can go back? Mr. Jimenez, we're going to come back on your case on October 25th. I want to make sure that your attorney has all the discovery, okay?
Yes, Your Honor. You have a good day.
All right, thank you. You too.
Thank you.
Patrick Valentine, you have Noah Cruz. We're going to take your plea up. Just give me a moment. Robert Brawback on Anthony George Cardenas.
Judge, I've signed, the paperwork has been signed. I don't know if Mr. Cardenas has signed it, but we're ready for the plea.
All right, I'm going to send you I don't think he's signed any paperwork because I haven't received any paperwork. Mr. Cardenas, I'm going to send you to breakout room number 1. Mr. Brawback, I'll send you to number 1. Let me find out which room you're in. And if you'll go over paperwork with him, please.
Yes, ma'am.
And to the courtroom, if I could have Noah Cruz. And who was the prosecutor working with, Mr. Valentine?
That was David. Noah Cruz should be others.
Ah, there he is. Okay. All right, and then Kevin, after this case, I'll send you to a breakout room with Mr. Cruz and with the courtroom. Court is calling 2021 CR 3083, State of Texas versus Noah Raul Cruz. Can I have parties announced for the record, please, for the state?
David Martin.
For the defense?
Patrick Valentine for Noah Cruz.
And are you Mr. Cruz?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objections from the state?
No objection.
Any objections from the defense?
No objections.
Mr. Cruz, I'm showing you what's entitled Defendant's Consent to Appear by Video. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
I believe I have, and yes, I did.
Court will find that the state is in compliance with discovery. Next, Mr. Cruz, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it? And did
Yes.
you? Yes, okay. Counsel, do you waive the reading of the indictment?
We so waive. Thank you.
State, are you proceeding on the indictment as presented?
Only on count 2, Judge. We're going to waive and abandon count 1.
No objection to that.
All right, just one moment. I don't, off the record, Brenna. So the court's file that I have for Noah Raul Cruz, the 2021 CR 3083, it's charging him with robbery. And then the indictment has it written as though it's an assault with the complainant of Michelle Grubbs. So there's something wrong with this file.
Flabbergasted by that. Let me pull it up real quick, Judge, and see what's going on.
Because it is 2021 CR 3083, is that correct?
Yes.
Now, I will tell you, the indictment is correct. The indictment matches your paperwork, but in the system somewhere, it has it as a robbery. Could I have one of the clerks, please?
I think it was initially brought in as a robbery. Let me look at the indictment real quick.
Sure. All right, everyone, just give me a moment.
Yeah, they just didn't label the counts, Judge. So I guess just the first paragraph that sets out a robbery charge, we can strike that. And then the second paragraph is the choking.
All right. And it's not listed as count 1, count 2 in the indictment. So I'm gonna
Right.
change
Yeah, I
that
don't know
to count 1.
what Bozo did that. But right. So we'll just strike the first paragraph.
So you're proceeding on count 2, and that's choking. Is that correct?
Yes.
All right. Any objections?
And I didn't mean any offense to any clowns out there.
All right. We're back on the record. Any objections with the state waiving count 1 defense?
No objection, Your Honor.
All right, Mr. Cruz, I'm going to show you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes.
Did you understand that the state is proceeding on count 2? That is an assault, family choking, strangulation. It's the 3rd-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you enter a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Mr. Cruz, did you understand that the court would grant your application for deferred adjudication if for any reason your deferred adjudication were revoked, the court could find you guilty, not grant you community supervision, and sentence you up to 10 years in prison and up to a $10,000 fine? Did you understand?
Yes.
Counsel, has your client been able to provide you with any defenses to this offense?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe so, Your Honor.
Mr. Cruz, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. I'm showing you the plea bargain agreement. Did you review that plea bargain with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, the state is proceeding on count 2, waiving count 1. The state recommends deferred adjudication. They will take in, JN number 1994242 will not be filed. There's to be restitution to Michelle Michelle, Grubbs, Grubbs. There's an affirmative finding of family violence, the BIPP course, no contact with Michelle Grubbs, and $100 to an approved family violence center. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes.
Did you understand that to be the entirety of your plea bargain agreement?
Yes.
Defense, is that the plea bargain agreement?
It is, Your Honor.
State, is that the plea bargain agreement?
Yes, sir.
Next, I'm showing you the paragraph entitled Waiver of Appeal. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement, the state is requesting that your deferred adjudication be for a term of 4 years and there be 120 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to count 2 in the indictment, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence to support the defendant's guilty plea?
Offer states want any attachments?
Any objections?
No objections.
Mr. Cruz, I'm showing you what's entitled Waiving Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
Yes.
All right, after reviewing states exhibits 1 and attachments, the court will find that there is sufficient evidence to find you guilty. However, the court will defer finding of guilt as you apply for deferred adjudication. Are we proceeding with sentencing?
No objection to proceeding today from the defense.
Anything you want to state on behalf of your client?
I'd just like to say we appreciate the state's recommendation. We do believe that Mr. Cruz presents an excellent candidate for deferred adjudication supervision, and we would ask the court to follow the plea bargain agreement.
Mr. Cruz, do you have any children?
No, ma'am.
All right, what was going on this day? Why did you do this?
Just acted out of emotions. Just reacted off of really emotions and didn't handle my situation the best way I could have that day.
How old are you?
I'm 21 now.
All right, you're 21 years old. You know what an ex-girlfriend means?
Yes.
That means they don't want you anymore. It's an ex.
Mhm.
Ex-boyfriend. You know what that means? He doesn't want you anymore. That relationship is over. You don't have any children with her. There's no need to be contacting her. Do you understand?
Yes, ma'am.
When people don't want you anymore, you move on. Right?
Yes, ma'am.
I don't understand why when people have known someone for less time than they've been on the planet, they act as though they want to keep them in a relationship. You have no right to unlock somebody's phone and go through somebody's phone. Do you understand?
Yes, ma'am.
Are you employed?
Yes, ma'am.
What do you do?
Electrical.
All right, this is what the court is going to do. Sentence you to 4 years deferred adjudication. Take in consideration JN number 1994242. There's an affirmative finding of family violence. The BIPP course, $100 to an approved family violence center. There's to be regular UAs, or you can do the patch. There's to be no contact with Michelle Grubbs. 120 hours community service restitution. The court will waive 40 of those hours if you obtain or have obtained the COVID vaccine. I'm not forcing anyone to get the vaccine, but if you are so inclined, then 40 hours will be deducted from your community supervision hours. Proof of employment within 30 days. There's to be no employment as a home healthcare provider or any employment involving minors. There's to be regular Zoom reporting. If something happens and you're not able to report by Zoom, then you're to report in person. All right, Kevin, is there anything else that Mr. Cruz needs?
I think we got it, but was there a fine? I didn't hear that.
No, there's no fine.
Okay.
All right, Mr. Cruz, is there anything else you need from the court in order to be successful?
No, ma'am.
All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. And because this is an affirmative finding of family violence and you're on probation, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
And under no circumstances are you to have contact with Michelle Grubbs. You understand?
Yes, ma'am.
We're gonna go off the record, Brenna. This is my relationship advice for you. I give this to everyone who's in a relationship or want to be in a relationship. Before you start another relationship, get an orchid. They have the orchids at the HEB, at Walmart, other stores. I think they're like $12.
Mm-hmm.
Keep that orchid for a year. Because when you first get it from the store, it looks all pretty, has flowers on it.
Mm-hmm.
Keep it for a year. Once those flowers fall off, if you are able to keep that orchid alive and blooming for a year, then maybe you're ready for a relationship. Because orchids require patience. You can't overwater, can't underwater them, can't move them around much. So if you're able to do that, you will have the patience for a relationship. I'm going to send you to breakout room number 2 and to the courtroom. If you could go to number 2, and probation will go over conditions with you. And Mr. Valentine, you're excused, or if you would like to go to breakout room number 2 with your client, you can.
That won't be necessary, but when the court has time, I'm available to speak about that writ of habeas corpus.
All right, so what I'll do on the writ of habeas corpus, I'm going to send you to breakout room number 3 with number 4 with Miss Ferguson. So you can give her the update on that, please.
Thank you, Judge.
You're welcome. And Mr. Cruz, you need to go to breakout room number 2. You've been requested to go there. And to the courtroom, if you could go to breakout room number 2 as well. All right, everyone, just give us a moment. Now, Brendan, do you need your break?
Yes, I'll be right back.
All right, we're going to take a 5-minute break. So everyone, please continue to put some patience in your pocket. We will be right back. All right, Orlando Castagnone on Trey Duncan. What are we doing?
Judge, he's now present. I had stepped away and I came back, so I didn't get an opportunity to confer with anybody.
Oh, you haven't conferred yet. Who were you conferring with last time?
I just got appointed on this case, the last setting, and so I haven't really conferred with anybody.
Okay, let me send you to breakout room number 4. And it's on Trey Duncan. And then Ed Garza on Gracie Sandoval Cruz. What is happening?
Yes, Your Honor. We just, we need the consent to conduct the hearing on video conference, and I believe we're going to move for a modification of her conditions.
Okay.
It's on its way, Judge.
All right, thank you.
Thank you.
Oh, Kevin, you finished?
Yes, ma'am.
Awesome.
Are we jumping into something right now?
We're going to take up another plea, and that plea, and then we're going to do Gracie Sandoval. And my understanding on Miss Gracie Sandoval Cruz, there is an agreement on that.
Okay, sounds good.
And so I think the next plea is going to be on Brawback and Cardenas.
Yes, ma'am, Judge, we're ready.
All right, just give me a moment. And Kevin, we were supposed to have a compliance hearing on Robert Richardson.
Richardson, okay.
Yes, and he is not on the Zoom, and I don't know if he's in the courtroom or not. I don't think he is. So whenever we can get him. And then we're going to take up Anthony Cardenas. Who's the prosecutor on Anthony Cardenas?
Hunter Morris, Your Honor.
All right. Hunter, are you there?
Yes, ma'am.
Okay. Brenda, I don't want to jinx it, but the spotlight has been working today. I don't know why. Other days it caused so much problems. All right, the court is calling 2021 CR 8400W, State of Texas versus Anthony George Cardenas. Can I have parties announced for the record for the state? For the defense?
Robert Brawback.
And are you Anthony Cardenas?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objections from the state?
None, Judge.
Any objections from the defense?
No objection.
Mr. Cardenas, I'm showing you a document entitled Defendant's Consent to Appear by Video Conference. Did you review that document with your attorney? Did you understand it? Did you electronically sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Mr. Cardenas, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Counsel, I'm showing you the acknowledgement of discovery. Have you received all the discovery in this case, and did you review it with your client?
Yes, ma'am, I did, and I reviewed it with my client.
Court will find that the state is in compliance with discovery. Mr. Cardenas, I'm going to show you what's entitled Waiver of Indictment, Reading of Information, and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Did you understand by signing that you're waiving your right to have a grand jury hear the evidence in the case and make a decision on whether or not to hold you over for trial or indict the case? And also you're waiving certain rights your attorney has, namely 2 days from the presentation of the information and 10 days from the presentation of the information to prepare for trial. Did you understand?
Yes, ma'am.
Did you understand by entering this plea bargain agreement you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived indictment, reading of information, and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Mr. Cardenas, I'm showing you what's entitled information. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the information?
Yes, ma'am, I do.
State, are you proceeding on the information as presented?
Yes, Judge.
Mr. Cardenas, I'm going to show you what's entitled court admonishments and defendant's waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Did you understand what you're charged with is possession of a controlled substance, penalty group 1 gram to 4 grams. That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you. You will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you're giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Did you understand that the court would grant your application for deferred adjudication if for any reason your deferred adjudication were revoked? The court could find you guilty, not grant you community supervision, and sentence you up to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, ma'am, he's legally competent.
Mr. Cardenas, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 6 years in the prison. There's a $1,000 fine, time and money to run concurrent. State will remain silent on your application for deferred adjudication or community supervision. State will take in consideration NIMAG number 614621, County Court cause numbers 662928, 662929, 662930. If a theft or vehicle case is submitted under SAPD 2109148, will be taken in consideration and included as restitution to the victim as part of this agreement. And that's determined by probation. Do you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
Yes.
State, is that the plea bargain agreement?
Yes, Judge.
Next, I'm going to show you the paragraph entitled waiver of appeal. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it?
Yes,
From
ma'am.
both places. Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
Oh, ma'am.
Then to the offense is charged and in the information, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence to support the defendant's no contest plea?
Did offer states one and attachments, Judge.
Any objections? Mr. Cardenas, I'm going to show you what's entitled waiver and consent and stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
What's your last name? Oh, they got it. Never mind. Hey, bro.
All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, but the court will defer finding of guilt as you've applied for deferred adjudication. Norma, I'll need a PSI date, please.
7 million fucking dollars. Yes, ma'am. And I did. I made 40 songs. Yeah, before I could drop it, I got locked up. 1 second, Judge. I'm gonna tell my girl to drop it on YouTube so y'all can look it up.
And for the record, the court is going to order a TAP evaluation. I want a referral to felony drug court, just a pre-evaluation to see if they will accept him or not. Mr. Cardenas, that doesn't mean I'm going to give you deferred adjudication. I haven't received any information, but in case I do, I would like the evaluation to felony drug court to already have been done, and you to remain in custody while that happens. Ms. Ferguson, a date?
18th?
October 18th?
Yes.
All right, we're going to come back on October 18th. Mr. Cardenas, it's very important that you are honest with probation and honest with felony drug court about your drug use. You understand?
Yes, ma'am.
All right, if there's nothing else, we will close the record. Mr. Cardenas, I'm going to send you to a breakout room with your attorney and with probation, and they will let you know what you need to do. I'm going to send you to breakout room number 2.
Yes, ma'am. Thank you. Have a
Thank
blessed
you.
Thank you, Judge.
All right, you have
Judge, may I
one
be
station.
excused after that? After the
Yes.
breakout room? Thank you.
Yes.
Okay.
All right. Just give us a moment, Mr. Garza. As soon as I get your paperwork, we'll go for it.
Yes, ma'am. Thank you, Your Honor.
All right, you're welcome.
How do I go to the breakout room?
All right, Mr. Cardenas, do you see at the bottom of your screen where it says breakout rooms?
No, it says leave. 1 second.
No, you don't want to leave.
Okay. Oh, breakout rooms. Yes, ma'am. I
Yes.
see it.
All right,
Okay.
thank you.
Thank you.
And then Kevin, I think I've assigned you already to number 2.
You want me to go now or you got something?
You can go now.
Okay.
We're gonna wait for I think we have paperwork outstanding on Sandoval. So as soon as she does that, then we'll take her up. But I know at the jail, they're shorthanded, so it'll probably be best to just go ahead and take care of that while you're in.
She's in the courtroom, Your Honor.
No, I'm speaking about Mr. Cardenas.
Oh, I'm sorry.
That's okay.
I'm
But
jumping in.
your client is signing paperwork, I know.
Right.
All right, clerks, if you could, you should have paperwork on Sandoval. All right, and to the court, if you could have Ms. Sandoval come forward, please. And who was the prosecutor on this?
Marcus Sanders, Your Honor.
Just face forward. So.
All right, the court is calling 2016 CR 11602, State of Texas versus Gracie Marie Sandoval Cruz. Can I have the parties announced for the record for the state?
Marcus Sanders.
For the defense?
Ed Garza.
And are you Miss Sandoval Cruz? Thanks, Lupe.
Yes, ma'am.
We're proceeding by video because of the pandemic. I'll note for the record that Miss Sandoval Cruz is in the courtroom. Any objections to us proceeding by video, state?
None.
Defense?
No, Your Honor.
Ms. Cruz, I'm going to show you what's entitled Defendant's Consent to Appear by Video Conference. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Court will find the defendant has knowingly and voluntarily consented to appear by video. Next, I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Gracie Marie Sandoval Cruz who was placed on deferred adjudication for the offense of forgery? Is there a motion to amend the paragraph for the offense because it's listed as forged writing? And I believe it should be forgery of a commercial instrument or check.
Yes, Judge, the state would move to do that.
Any objections?
No objection, Your Honor.
All right. Are you the same Gracie Marie Sandoval Cruz who was placed on deferred adjudication for the offense of forgery of commercial instrument of check on September 5th, 2017 for a period of 2 years and extended for a total of 2 years and 6 months? Is that you?
Yes, ma'am.
State?
Condition number 10F in Bexar County, Texas, between the date the defendant, Gracie Marie Sandoval Cruz, was placed on community supervision and the date of filing hereof. For restitution, the defendant should have remitted $3,500, but has only remitted $1,886 in violation of condition number 10F.
All right. How do you plead to that? True or not true?
True.
We'll waive the others.
You know what? I'm sorry. Let's go back. They're actually charging her as a forged writing because they're charging her as a Class A misdemeanor. That's what I'm checking from the stipulations. Let me see the defense in the state in a breakout room. If we can go to breakout room number 6, please. And Ms. Cruz, if you'll just give us a moment, please.
Yes, ma'am.
Or are we between cases right now?
They're in a breakout room for a second.
Okay.
All right, so we are back. All right, we're back on the record. And the motion to revoke was correct as written because it's listed as a Class A misdemeanor. So, Miss Gracie Marie Sandoval Cruz, are you the same Gracie Marie Sandoval Cruz who was placed on deferred adjudication in 2016 CR 11602 for the offense of forged writing on September 5th, 2017 for a period of 2 years and extended for a total of 2 years and 6 months? Is that you?
Yes, ma'am.
All right. The state had previously read to you violation of condition 10F. How do you plead to that, true or not true?
True.
All right, state,
We waive the other, Judge.
any objections to the state's waiver?
No, Your Honor.
Miss Sandoval Cruz, did you understand by pleading true to violation of condition 10F, the court could find it true, grant the motion, sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition 10F?
Yes, ma'am.
I'm sorry?
Yes, ma'am.
All right, the court will find 10F true. Is there an agreement?
Yes, Judge, we are asking that you deny the motion, alternate amend to order biweekly UAs for 90 days. Also, the defendant is to make a $400 payment today to probation with monthly payments to follow and verification of employment.
That is our agreement, Your Honor.
Okay. All right, Ms. Sandoval Cruz, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. All right, Ms. Cruz, if you're drug tested today, what are the results going to be?
Negative.
All right, because I'm going to have you get drug tested today, you understand?
Yes, ma'am.
All right, so you're going to pay $400 to probation today?
Yes, ma'am.
And have you calculated how much you'll be able to pay towards this restitution per month?
I have not. I did have something planned for this weekend to make a bigger payment. Me and my sister, she's gonna help me do a plate sale. Then whatever I get from that, I'm gonna pay it towards my probation.
All right, so this is what you're gonna have to do, Miss Sandoval Cruz. You need to sit down, figure out what your budget is, and figure out how much you can afford to pay each month. You understand?
Yes, ma'am.
So it's not my intention for people to end up becoming homeless because they're trying to pay things. But this person wants their restitution because you forged a commercial instrument. And because of that, they don't have $3,500. So they want their $3,500 back. So you're gonna have to start working towards completing that payment. You understand?
Yes, ma'am.
All right. So I'm going to say that she's to provide a budget to probation by all right, you're going to need to provide a budget to probation by September 24th.
Yes, ma'am.
And who knows, probation may be able to figure out your budget now before you leave court. So that's the court's orders. Is there anything else?
No, Your Honor, nothing else from the defense.
All right, we'll close the record. Good luck, Ms. Cruz. I'm going to send you to breakout room with probation. And if you will go to breakout room, let me see where we are here. Courtroom, if you could go to number 1, please. And Kevin, if you can go to number 1. And Mr. Garza, you can go to number 1 or either you can be excused. And Kevin, did you finish with Mr. Cardenas?
He's done. Yes.
All right, Norma, can you make sure 16F goes back?
Judge, can I just clarify on this one? I just want to make sure. So $400 payment today, submit
Yes.
UA today, provide budget plan by the 24th. And was there biweekly UAs or just the UA today?
Bi-weekly UAs for 90 days.
Got it. Okay.
And of course, Kevin, if probation feels that she doesn't have a drug problem, then just let the court know and I'll reconsider the bi-weekly UAs.
Okay.
All right, thank you.
Thank you, Your Honor. May I be excused?
Yes.
I have to go to HEB curbside.
Oh, well, I hope they have your order correct.
I do too. Thank you, Judge. Have a good weekend.
All right, thank you, you too. Norma, can you see where Mr. Ed Bartolome is?
Yes, ma'am.
I think if we finish everything, we will not have to come back this afternoon, but we shall see what happens. Hello, everyone's back. So on Trey Duncan, what is happening? And you're on mute. Whenever you come out of the breakout rooms, you're muted. Yes.
Were you talking to me, Judge? I apologize.
Taxi driver. Yes, I was.
Okay, I'm sorry. I was on mute because it was on the phone. But I've conferred with the state on Duncan. This is my first appearance after the first appearance I was appointed on. I've gone through some of the discovery. We've conferred some on the case. I have
Okay.
not gone over this case with my client.
All right, and I see where you were just appointed, I think August 11th or whatever. I will give you a reset date. Mr. Duncan, you need to show your video.
I don't know if you fell asleep.
I don't know, but Trey Duncan, next time, if you do not appear on here with your video shown, you'll be required to appear in court. So if there's something wrong with your Zoom or something else that's going on, you will need to appear in court. Ms. Ferguson, can I have a 30-day reset, please? And we'll just put it as discovery.
The 21st, Judge.
All right, we'll see you back on October 21st.
I think on the 21st, I have a vacation letter in.
Where are you going?
The plan is we're supposed to be going to Disney. My kids
you
have a
to
week
let me
off
know
in
how it
October.
is.
What's that?
You will have to let me know if it's a small world after all or not.
I've never been. There's talk that we might put it off because we're afraid that too much stuff is going to be closed and not worth it.
Yeah, I've never been either, but one of my students told me to go to, is it Warner's or whatever, where they have Harry Potter?
The Universal Studios, yeah.
Yes, University. And Brenda, whenever I say Harry Potter, I don't know why I do that little accent. Okay. So Norma, we need another date other than October 21st. How long are you going to be gone?
That week. I think we're coming back like that Friday.
All right. So you want to do it Friday after, Norma?
I can do the 27th, Judge.
27th?
Yes, ma'am.
That works with me.
All right. I hope you still have your vacation glow by that time.
Well, I'm looking forward to finally going somewhere after all this done.
Well, my favorite place is Paris, and I haven't been back there, so hopefully soon. All right, then you and your client are excused. We'll be back on October 27th.
Thank you, Judge. And you can see Mr. Duncan is on camera.
Yes.
Thank you, Judge. Y'all have a good weekend.
All right, thank you, you too. All right, Denny Callahan.
Hi, Judge. Can I have my client, please? He's in the courtroom.
All right. Mr. Flores, if you can just give them a moment. The courtroom is in the breakout room with another client. So as soon as they're finished, I'll put you in the client with your, I'll put you in the room with your client.
Thank you.
And Norma, any updates on Mr. Michael Griffin?
Trying to get a hold of Mr. Bartolome, Judge.
Thank you.
Judge, can I see you in a breakout room?
Yes. Breakout room number 3.
Thank you.
And Mr. Morris or one of the prosecutors, if the courtroom becomes available while I'm in the breakout room, if you could send Mr. Callahan and his client, which is in the courtroom, to another breakout room, please.
Okay, Judge.
Courtroom, if you can go back to number 4, please. Vincent Callahan needs to speak with his client.
Thank you.
You're welcome.
Judge, I'm gonna step away for just a moment.
Okay.
Judge Callahan.
Yes.
We have an agreement.
Okay, and is it to be continued or no?
10 years probation. They're going to have a counselor from probation come over and work out a specified monthly payment. We're going to recommend $80 a month, which is double what he had been paying, roughly $43 a month, as within his capacity. That'll get us up to about 75% of the full restitution amount in 10 years. I don't want to say we're kicking the can down the road, but it's better than going to prison, and at least we'll get more restitution.
All right, could I have the courtroom, could I have Mr. Flores come forward, please? Armando Flores, courtroom. All right, thank you. Who's the prosecutor?
Hunter Morris, Judge. And Denny, what was that amount that you were proposing?
80.
Oh, okay, what we talked about, okay.
All right, the court is calling 2011 CR 4114A. Just one moment. If this is going to end up being a conviction, he's going to have to do a trial court certification, because we're going from deferred to a 10-year sentence.
I understand. Can we do it on just by speaking and do it later?
No, he'll need to fill out the application for trial court certification of defendant's rights to appeal. Norma, can you get that to them, please?
Yes, I'll do it right now, Judge. It won't take me but 2 minutes.
All right, it will take her 2 minutes.
Mr. Flores?
Yes, sir.
You're signing a paper that says you do not have the right to appeal, and you say, I know that, and you sign it.
Sure.
Monitor, I sent you a chat.
Okay, Mr. Callahan, it should be in your email.
You say you sent it to me also?
Yes, it goes to you first and then to the defendant. Well, it'll go to Norma the bailiff.
Got it.
Great.
Done.
Mr. Flores.
All right, we are back on the record and cause number 2011 CR 3414A, State of Texas versus Armando Flores. Can I have parties announced for the record for the state?
Hunter Morris.
For the defense?
Denny Callahan.
And are you Mr. Flores?
Yes, ma'am.
We're proceeding by video because of the pandemic. I'll note for the record that the defendant is in the courtroom. Any objections to us proceeding by video, state?
No, Judge.
Defense?
No, Your Honor.
Mr. Flores, do you have any objections with us proceeding by video?
No, sir. No, ma'am.
Did you sign the document entitled Defendant's Consent to Appear by Video? Did you review it with your attorney? Did you understand it?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily consented to appear by video. I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Armando Flores who was placed on deferred adjudication in 2011 CR 3414A for the offense of arson on September 19, 2011 for a period of 10 years? Is that you?
Yes, Your Honor.
State?
In Bexar County, Texas, between the date the defendant Armando Flores was placed on community supervision and the date of filing hereof for restitution, the defendant should have remitted $19,895.31, but has only remitted $5,256.50 in violation of condition number 10D.
How do you plead to that, true or not true?
Not true, Your Honor.
No, Your Honor. He's listening to old advice. We've changed our strategy. It's true.
True, Your Honor.
I'm sorry, Mr. Flores, is it true or not true?
True, Your Honor.
All right. Did you understand by pleading true to violation of condition number 10D, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to $10,000 fine? Did you understand?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition 10D?
Yes, Your Honor.
All right, the court will find violation of condition 10D true. Is there an agreement?
Yes, Judge. For the plea of true, revoke, defer, adjudicate guilty, but place on community supervision. The underlying term is less important than the supervision term. I guess 10 years. Amend the conditions to include a minimum of $80 per month in payment towards restitution.
Correct.
All right, so your agreement, do you have an agreement on the underlying?
2 years, Judge, is fine.
Any objections? Is that the agreement, Mr. Callahan?
No objection. That is the agreement.
Mr. Flores, are you asking the court to follow that agreement?
Yes, ma'am.
All right, so this is what the court is going to do. The court is going to find you guilty, not send you to prison. I'm going to grant you community supervision. I'm going to sentence you to 2 years in the prison, suspended and probated for 10 years. There's an $80 restitution. You're to pay $80 per month, and the total amount of restitution due is, what is the total amount due, please? Is it the 5,000 minus the 19? I'm sorry, the 19,000 minus the 5,000? Is that correct?
Yes, Judge.
Yes, Judge.
And I would note just
yes,
for the court's just for the record, I note that if the defendant pays $80 per month for the next 10 years, he will be at about 75% of the restitution. And the state's aware of that and does not intend on filing an MTR if he's compliant with those monthly payments, knowing that he will still be short of the total amount.
All right, the total amount of restitution due then is $14,638.81. That's based upon the amount that the defendant has previously paid, which according to the motion to revoke is $5,256.50. So you're to pay, Mr. Flores, each month, you're to pay $80 towards restitution. Do you understand?
Yes, ma'am.
Now, Mr. Flores, here's the thing. People see that $80 a month and they backtrack. They say, I'll just catch up on our next month and I'll pay $160. And then before you look at it, you have not followed through on your agreement. You understand?
Yes, Your Honor.
I understand that people have financial situations, but the person that you owe this money to, they want their money. All right?
Yes, ma'am.
So it will be 10D is true. Find the defendant guilty. Grant him community supervision. Are you employed?
Yes, ma'am.
All right, there's going to be proof of employment within 10 days. No employment as a home health care provider or any employment involving minors. And the main thing is for you to pay this money. You understand?
Yes, ma'am.
Are you able to report by Zoom?
Yes, ma'am.
All right, there's going to be regular Zoom reporting. And that is all the court is going to order. Well, I'll add regular UAs. That is all I'm going to order. So you are to make sure that you pay that amount. Do you understand?
Yes, ma'am, I do.
Okay. All right, is there anything else from either side with regards to sentencing?
Nothing from the state, Judge.
No, Your Honor.
Mr. Flores, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And also because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, I'm going to send you to breakout room number 1. And the probation officer will meet you in number 1. And with that, we will close the record.
Thank you, ma'am.
Thank you, Your Honor.
Thank you, Mr. Callahan. Have a great rest of your weekend.
You too. Thanks, Hunter. Bye-bye. Good to see you, Brenda.
Bye-bye. Well, everyone, we are done for today. So we're not going to be back this afternoon. Where is Meredith and Marcus and David Martin and Joe Ray Garcia and Norma? All right, guys, have a good weekend. As always, as I always say, please be safe out there.
Where's Timothy?
Yeah, where's Timothy? Tom, he's still out. Okay, everyone, please social distance, wear your mask, be safe out there. And if anyone is barbecuing, let me know because I'll do a curbside pickup. All right, guys, have a good weekend.
All right, see ya.
All right, bye.